Good day, gentlemen. My paper ID is ERCICSTRA 2007063, and the title of my paper is Instituting Fundamental Rights Actions in Nigeria, Unresolved Issues. Fundamental rights actions are unarguably one of the most litigated areas in Nigeria. The reasons are not far-fetched, as lawlessness, recklessness, and brutality is customary with Nigerian security outfits. The cause, to some extent, can be commended for having done a lot of work to advance fundamental rights litigations. But then, two major areas still remain unresolved, and they are considered as major setbacks to fundamental rights litigations in Nigeria. These areas are, as it concerns the jurisdiction of the court and locus standi, the question of locus standi. The legal framework that I'm going to consider in this work are the following: the Constitution of the Federal Republic of Nigeria 1999 as amended, maybe making some references to African Charter on Human and People's Rights Ratification Enforcement Act 2004 where necessary, and then Fundamental Rights Enforcement Procedure Rules 2009. For the purposes of this paper, I'll just call it FREP rules, the FREP rules. Then the provisions that I'm going to focus on while discussing this paper are extensively Chapter 4 of the Constitution of the Federal Republic of Nigeria, which I shall hereinafter refer to as the Constitution, Section 230 and Section 251 of the Constitution in respect of the jurisdictions of the courts, and then also Section 272 of the Constitution, and lastly Section 46, subsection 1 of the same Constitution. The first point of call here is to discuss the jurisdictional issue. Looking at the jurisdictional debacle, the first thing we need to know is that the jurisdiction to entertain fundamental rights actions is vested both on the state high court and on the federal high court. The jurisdiction of the federal high court is exclusive to it, and it is stipulated in Section 251, subsection 1 of the Constitution, while the jurisdiction of the state high courts are limited to the extent of the matters listed in Section 251, subsection 1 of the Constitution. In other words, the state high courts have unlimited jurisdiction except for matters falling within the jurisdiction of the federal high court. The first test case we are going to consider in respect of the issue of jurisdiction in fundamental rights litigation in Nigeria is the case of Tukuru against government of Gongola State, citation already provided. The facts of this case show that the appellant was removed by the military governor of Gongola State as the emir of Muri and ordered to be detained at Muri. He filed an application for the enforcement of his fundamental right at the Federal High Court in Kano, seeking for his deposition to be quashed as he was not accorded fair hearing in the process, which resulted into the deposition. Now, the vital issue that arose was whether the Federal High Court had the jurisdiction to entertain the matter. It was the view of that Federal High Court, the court that heard the matter, that it had concurrent jurisdiction with that of State High Court. When this matter eventually got to Supreme Court, the Supreme Court held that Section 42, subsection 3 of the then 1979 Constitution, which is now Section 46, subsection 1 of the present Constitution, 1999 Constitution as amended, has by the opening phrase, which says, subject to the provision of the Constitution, limited the jurisdiction of the Federal High Court to enforce fundamental rights to provisions relating to matters conferred on it by the extant provisions of the Constitution. In other words, what the Supreme Court was simply saying is that Federal High Court cannot entertain an action on fundamental right except the subject matter touches any of the matters vested on it by the Constitution. The Supreme Court was, in other words, applying the subject matter jurisdiction, or what is called the transaction test. So by so applying, the Supreme Court said that the Federal High Court must limit itself to all the subject matters to which it is circumscribed in the Constitution. Now, the next case that followed this very case along the line of the jurisdictional debacle is the case of Alhaji Gafar against government of Kwara State. Alhaji Gafar against government of Kwara State. This matter pertains to an action instituted by the appellant as an applicant at the Federal High Court in Ilorin, challenging the government directive for him to pay or refund the sum of 2 million naira, or on the failure to do so to forfeit his personal assets, having been indicted by the Commission of Inquiry. He filed an application for enforcement of fundamental rights at the Federal High Court. The respondent had no right to try and find him guilty was one of the issues he raised at the court. But then the jurisdiction of the Federal High Court to entertain such an action was challenged by way of preliminary objection. The court dismissed the preliminary objection, holding that it had jurisdiction. We need to bear in mind that this action is against a state government, but it was instituted at the Federal High Court. The Federal High Court held that it had jurisdiction to entertain the matter. Of course, the respondent was not satisfied with the outcome of the ruling, so he appealed to the Court of Appeal. The matter eventually got to the Supreme Court. The Appeals Court dismissed the appeal, holding that both the State High Court and the Federal High Court has concurrent jurisdiction in all matters dealing with enforcement of fundamental rights, and that an application may be made either to the Judicial Division of the Federal High Court in the state or to the High Court of that very state. The Appeals Court in this very case cited its decision in Chukru against government of Gongolo State, which we had earlier cited. In other words, when you consider the decision of the Supreme Court here, it will appear as if a litigant in a fundamental rights action has the right to pick and choose which court to go to, provided his state has a state high court as well as the Federal High Court. At least that's the impression these decisions have given. Now again, there's something that is very instructional that I want to bring out from the dictum of the Supreme Court, especially the pronouncement of Onohen JSC. He says that it therefore follows that the enforcement of the appellant's fundamental right is interwoven with the proceeding and recommendation of the Commission of Inquiry, as there is no way by which the alleged rights can be enforced without a determination of how the rights were allegedly infringed by the Commission. That will surely call for a complete examination or overhaul of the proceedings or of the activities of the said Commission of Inquiry, and it will be impossible to do that without stepping out of the limits of the jurisdiction of the trial court. The link between this decision and that of Chukru against the government of Gongola State can be deciphered by the court's own pronouncement, which says that Federal High Court cannot adjudicate on matters concerning a state government. In other words, the Supreme Court here now also dragged into its decision the issue of jurisdiction in personam. Mind you, what they talked about in the two previous cases cited were issues of subject matter jurisdiction. But at the later part of this decision, they are now talking about jurisdiction in personam, which means the institution sued. And the Supreme Court said that you cannot sue a state government before a federal high court. It continued by saying this is because the federal high court has limited jurisdiction, while by section 236 subsection 1 of the 1979 Constitution, a state high court has unlimited jurisdiction to hear and determine any civil proceedings in which the existence or extent of a legal right, power, duty, liability, privilege, interest, obligation, or claim is an issue. One may dare to agree with the decision of this Supreme Court in respect of the two cases that we have cited. But let's now consider what happened 15 years after that decision, after those decisions. 15 years after, the Supreme Court had opportunity of entertaining the case of Grace Jack against University of Agriculture, Makurdi. Grace Jack against University of Agriculture, Makurdi. In this very case, the appellant sued a federal agency, which is the university, to enforce her violated fundamental rights. The reliefs asked for actually didn't fall within the purview of Chapter 4 of the Constitution, but what is of interest in this discourse is the attitude of the Supreme Court, the holding of the Supreme Court. How did the Supreme Court look at the matter? When the matter eventually got to the Supreme Court nevertheless didn't pronounce upon whether a state high court has the right to entertain a matter affecting a federal agency, that's the University of Agriculture, which by section 251, subsection 1 of the Constitution ought to have been or is within the jurisdiction of the federal high court. The Supreme Court didn't go there. But what the Supreme Court simply did was to hold that where a state high court and federal high court exists in a particular state, that an applicant for enforcement of fundamental right can pick and choose, can decide on which particular court to go to. Now, in other words, sections 230 and 251 of the Constitution, which delineate the subject matter and party jurisdiction, as well as jurisdiction in personam of both the federal high court and the state high court, we are not reckoned with. But what the Supreme Court concentrated on was section 46, which is a special provision section. Section 46. Now, if this is the true interpretation and intendment of the Supreme Court, the question is, why then did it rely on the subject matter jurisdiction in its decision in the case of Chukwu against government of Gongola State? There is obviously confusion there. There are questions to be answered there. Following this case is the case of Adetona against Igere General Enterprises Limited, citation also provided. This case actually was not a case anchored on enforcement of fundamental right. But the Supreme Court decision in this very case is very, very instructional. Here, the Supreme Court upheld the reasoning that the action was based on tort and went ahead to state that what determines jurisdiction in fundamental right actions is the subject matter, thus revisiting and upholding its decision in the case of Chukwu against government of Gongola State and remaining silent on its decision on Grace Jack against University of Makurdi. In the recent time, one would have thought that this confusion created in the two decisions of the Apex Court could be corrected in their recent decisions. But in the case of EFCC against Wolfgang Renel, citation also provided, a federal agency was sued, that's the EFCC, being a federal agency, was sued in the State High Court for enforcement of fundamental rights. The court relied on the concurrent jurisdiction rule which it enunciated in the case of Grace Jack. the court did not bother to address the issue of whether a federal agency could be sued in a state high court. The court did not resolve that very issue. The same thing also happened in the case of EFCC against Libe Ruche. Citation also provided in the article. The Court of Appeal, Port Harcourt Division, relied on the decision of Grace Jack to hold that where both the High Court and the Federal High Court exist in a state, they have concurrent jurisdiction. In other words, the issue of jurisdiction in personam was played down. Also, the issue of jurisdiction of concerning subject matter was equally played down. What was of primary importance to them was that it was the issue of whether in a particular state where the infraction was alleged to have been committed, was there a state high court and a federal high court? If the answer is yes, then the applicant could pick and choose. This obviously does not make our law certain. It has not helped fundamental right litigations in any manner. To sum it up, therefore, it means that where the test in Tukro's case is applied, the jurisdiction of the Federal High Court and the State High Court will be interpreted subject to their various subject matter jurisdiction. But when the test in Grace Jack's case is applied, the issue would be whether both courts exist in a state. This is a state of confusion, and this confusion is still looming and requires to be clarified once and for all. Then we go back to the second issue. The second issue has to do with the issue of local standi in filing an action for enforcement of fundamental rights. The issue of local standi, simply put, is it possible for more than one applicant to bring an application for enforcement of fundamental rights action? This is a very, very crucial issue. In other words, whether more than one applicant can bring an action for enforcement of fundamental rights. I'll give you an instance. If somebody's right was violated alongside the rights of members of his family, would he be correct to lump the names of members of his family in the application as applicants for the enforcement of their fundamental right? This question was answered in the negative in the case of Moraro and another against Yedi. Citation also provided. Here, the Court of Appeal held that more than one applicant cannot bring an application for enforcement of fundamental rights under the FREP rules, 1979. In another case, Okechukwu against Etukoku, citation also provided. Some of the issues that were determined by the Court of Appeal Enugu Division included whether the rights allegedly violated by the respondent can be ventilated in respect of numerous or more than one applicant, can be ventilated by numerous or more than one applicant. Or assuming that the right or rights are threatened as civil rights and obligations, whether the fundamental rights enforcement procedure rules can properly be invoked to challenge the proceeding concerning that particular subject matter. Now, in reaching its decision, the court held that a family as a unit cannot commence an action on infringement or contravention of fundamental rights. This is obviously a worrisome decision, and it's very, very unfortunate that if a family member, the rights of all the family members are violated, and those rights have their plank within Chapter 4 of the Constitution of the Federal Republic of Nigeria, all the family members cannot be applicants in one suit. The question is, what would the law lose? Or what would the society lose if you have multiple applicants that have the same cause of action under fundamental rights enforcement procedure rules? Or like we are going to posit now. We are going to posit that this very law ought to be amended. But before going to that extent, we need to cite an undecided case. But this undecided case, by the way, is a decision of a court that is inferior to the court that decided the other matters. In other words, we are looking at the decision of the Federal High Court, whereas the two cases I cited earlier were decisions of the Court of Appeal. So by the rule of judicial precedent, this inferior court or lower court, the Federal High Court, ought to have followed the decisions of the Court of Appeal. But it refused to do that. I'm talking about the case of Gifted Hands Interior and Home Constructions and another against Mrs. Ampiton Bolanle and another. In this very case, the learned trial judge reasoned that the FREP rules under which Bararo and another Anyedi was decided was restrictive in nature, while the FREP rules of 2009 brought changes which de-emphasized technicalities in favor of substantial justice. Inasmuch as Milord, the judge that handled this matter, did not like the decision in Bararo's case, but the point remains that my lord did not anchor his own decision on a better reasoning or on some philosophy that can actually be said to be the main purport of the new rule 2009. For the judge to say that the 1979 rules under which Bararo's case was decided was restrictive in nature, talking about technicalities, was putting it too wide. It ought to have been anchored on a particular precinct of the law. Now, the problem stems from the interpretation of the word any person, as is contained in section 46, subsection 1 of the Constitution. It is submitted that if the said words are subject to their ordinary and literal meaning, they cannot mean more than referring to a person, and that is why Order 6 Rule 1 of the FREP rules allows for consolidation of applications relating to the same infringement. So, which means if you look at it, you will now agree that the decision in Bararo and the decision in Bararo's case was correctly decided, albeit unfortunately, but it was the correct interpretation of the law. But then the question is this state of law good for us? The answer is basically no. It is submitted, therefore, that housing the local standard of more than one applicant to bring fundamental right actions has not taken into purview the philosophy of the FREP rules. It has not taken into cognition at all the main purpose, the main intent of the new FREP rules. Because the real intention of the new FREP rules is to liberalize institution or litigation of fundamental right action. And that is why even the new FREP rules has allowed amicus curiae to bring an applications for enforcement of fundamental right, NGOs to also bring an application for fundamental right. The question is, if NGOs and amicus curiae could be allowed to bring an application for enforcement of fundamental rights, what stops more than one applicant from bringing their own application for enforcement of the same infringement where there is the same cause of action? So in view of this fact, therefore, in the final analysis, it is hereby recommended that on the issue of jurisdiction, the Supreme Court should make its stand bold, should come out with a bold standard to distinguish its decisions in both Chukro's case and then the case of Grace Jack, and tell us which particular one is the law. Or in the alternative, there could be a case stated for the Supreme Court to give us an ascertainable position of the law as it regards the issue of jurisdiction. Now, on the issue of local standard, two things can be done. None of these cases cited above went to the Supreme Court. So the Supreme Court has not had the opportunity of entertaining matters concerning local standard, whether more than one applicant can bring a single application for enforcement of fundamental rights. And when this happens, the Supreme Court is urged to rule in favor of having more than one applicant bring an application for enforcement of fundamental rights. The second aspect of this recommendation would be to amend the FREP rules and make it very, very clear that more than one person can bring an application for enforcement of fundamental rights. This can also be done by amending section 46 subsection 1 of the Constitution and remove the words that is really causing the problem, any person. It will be better to make it to apply the plurality of language so that it will underscore the importance of more than one person bringing an action for enforcement of fundamental rights. With that, our law on fundamental right litigation in Nigeria will be more enriched. Thank you very much for having me. Thank you very much for listening.